Good morning, colleagues. The time is exactly 10 o'clock. Can I see the thumbs up if you can hear my voice because I'm muted, everyone? Thank you so much. I see the thumbs up. Okay, colleagues who are raising your hands, I just wanted to see the thumbs up if you can hear me. We're testing our sound. We don't want to disadvantage anyone. Thank you. Morning, colleagues and property practitioners and stakeholders. I want to welcome you to today's webinar. So today's session is very important because we're going to unpack key compliance and governance matters affecting the property sector. One of our topics, as we advertised, is beneficial ownership, and we want to understand what the beneficial ownership requirement entails. And we want to look through the methods and the processes of elimination, and also maybe take a look on practical examples to help you apply the principles correctly. We're also going to look at another topic that we have today from our second speaker, which is contract requirements and the intended guidelines under the Property Practitioners Act. As property practitioners, you play a very important role, especially in safeguarding the integrity of the property market, and also because you work with consumers. So today's session, we aim to provide clarity, just practical guidance and compliance direction, just to help you confidently meet your obligations, especially under the PPA. And we encourage open engagement. Feel free to post your questions in the chat. We will address them after the Q&A segments, and we will also share the presentation. Everyone who raised a hand right now, I am not going to recognize you. We're going to allow for the speakers to present. Then we will deal with the questions after the two presentations. Our first speaker is a guest speaker. Her name is Kayleen Edwards. She's a dedicated professional with a BCom law degree and also anti-money laundering practitioner here in South Africa. She has an extensive experience in the real estate sector where she developed a strong passion for compliance, especially adhering to the Financial Intelligence Center. And, she's been in this role for many years. As a member of Compliance Institute of South Africa, Kayleen has further honed her expertise in FICA compliance within the legal fraternity. Maybe also to touch on the aspect that Kayleen is a member of Moonstone Compliance, where she serves as an AML compliance. So she currently works for Moonstone Compliance as a consultant, and she provides governance structures with knowledge and tools to effectively fulfill the anti-money laundering that she's dealing with, because she's an expert in that. And then also our second speaker that we have, I'm sure most of you, if you've joined our webinars, you know her. Her name is Daylin Kambule. She is an admitted attorney currently working for the PPRA. Before Daly joined the PPRA, she practiced as an attorney in various law firms where, she joined the financial institutions. She worked for African Bank and she further moved to Standard Bank. And in 2008, when she joined the PPRA as a legal officer, she was also promoted to a legal manager at the time of the EAAA Act. You remember the Estate Agency Affairs Board. Then she moved on and was appointed acting as an executive manager in the enforcement and department. And in 2022, some of you would remember, she acted as a CEO for PPRA from April 2022 to February 2023. And later on, then she acted in another role as a chief operation officer from February to May. And she moved again to becoming now where she is in her current role as the manager of investigations, mediation, and adjudication. This is where we receive the complaints from consumers, and she takes the matters before adjudication to assess them. She also assists with appeals and also mediations as well, but she will touch on that as she's doing her presentation. She also acted as a transformation manager from 2023 to 2024, and she completed her acting recently now in the claims department, because we receive complaints as well from consumers who want to claim against the fund, especially if you use a practitioner who has a Fidelity Fund certificate. She also serves as an advisory board member for the Tshwane School for Business Society, and she's currently a board member now as we speak there. And behind her, she has qualifications, a BA law degree, a diploma in drafting contracts, and she also has a master's in business administration. She's very passionate about the sector, and especially supporting women in the transformation space. In her spare time, she's a developer. She developed several properties across South Africa where she's renting them out through an accredited property practitioner that has a valid Fidelity Fund certificate. So before we get into the presentations, I want to let everyone know that I've muted your mics so that we can allow the presentation, and we will take the questions after the presentations. You may use the chat box or the Q&A space to put your comments there and the questions. Please keep your questions relevant to today's topic. The session is being recorded for compliance and reference purposes. And I know there will be someone asking if I can get the slides. Yes, we will share the presentation slides, and the recorder is going to be on our PPRA TV that we usually post 24 hours after the webinar, so you can access it there. I'm going to allow our first speaker now. Without further delay, let us begin our discussion on beneficial ownership, and it will be followed by contract requirements. Let me allow Kelly. Are you ready with your presentation? I can stop flagging the handles of the social media and you can flag your presentation. Thank you.
Good morning, Naledi. Thank you very much. I'm just going to share my presentation. Okay. Good morning, everyone. Thank you, Naledi, very much for the introduction, and welcome to all the property practitioners. Before I start, I just want to make sure, Naledi, that you can see the presentation.
Yes, we can see the presentation. We can hear you. Colleagues, can we see the thumbs up? Yes, they can. They can.
Fantastic. Thank you very much. So, as the lady said, I'm Kayleen from Moonstone Compliance, and I will be discussing beneficial ownership today. So, this is a very, very important section in the Act, as are all the others. And it has been around before the blow up of the register with SIPC, and all the requirements became more in your face. Beneficial ownership was a requirement prior to 2022 with the General Laws Amendment Act. So you will see, or you will know that PCC 59 was issued in August 2024. That is not when beneficial ownership became a requirement. It was actually before that. The FEEC just provided this guidance product to help accountable institutions to fulfill that obligation in identifying beneficial owners of their client. The reason why the PCC was issued was also further from the FATF's recommendation number 24. When the FATF did their evaluation of South Africa, there was deficiencies with beneficial ownership. And that is where all the work was being done by the FEEC to assist accountable institutions to make sure that they are identifying beneficial owners of their client, because that is a very common trend internationally for criminals to hide who the owner is, or who's the one that benefits at the end of the day by whatever transaction they are involved in. So beneficial ownership, very, very important aspect, and it's very important that it is done correctly as per the Act. So you'll find it in Section 21B of FICA, the Financial Intelligence Center Act. What the FIC has said, what the comment they've made on this is that as part of establishing the ownership and control structure of the legal persons, trusts, and partnerships in terms of Section 21B1 of the FIC Act, the accountable institution must determine all natural persons who own or have control over the entity. It is from understanding the ownership and control structure that the accountable institution will be able to determine which natural persons it must identify as the beneficial owners in accordance with 21B, 2, 3, and 4 of FICA. So that is quite a mouthful, but simply put is you need to find the last warm body. That is what basically the requirement is. It is not an easy task. Sometimes it can become complicated, especially when your client is a complex structure. If you have a legal person who is a client and that client has a complex structure, ownership structure, it can become quite complicated. There is the process of elimination, which Naledi did mention, which assists accountable institutions to find out who the beneficial owner is. So there is help, there is guidance, and we will go into it more as we go along. Okay, so who is a beneficial owner? Your beneficial owner of your client is the natural person exercising effective control. And it is important to note
Sorry,
that,
Kaylin,
yes,
sorry to do this. I
fine.
see the chats, they can't see the presentation. Maybe if we can unflag and flag it again.
Okay, no problem.
Colleagues,
Okay,
can you now see the presentation? Can we see thumbs up or comment on the chat? Okay, they can see it. Thank you. Sorry about that.
no problem. Thank you, Naledi. So I'll just repeat that. Who is a beneficial owner of a client or a legal person or natural legal trust or partnership? So the beneficial owner is a natural person who exercises effective control of the client, and it can be more than one person. The rule of thumb is 5% or more shareholding or ownership in the client, which we will also get into. So there can be more than one person who owns more than 5% of your client, the legal structure. So it definitely is not just limited to one person who needs to be identified and verified in terms of the act. Okay. We also look at ultimate beneficial owner. So this is perhaps this person that has the biggest shareholding of your client. Who is the person who has control of what happens in that legal structure? Who is the person whose say is the last say? Who is the person that ultimately benefits from that legal structure? That is your ultimate beneficial owner. And when it comes to beneficial ownership, it is important to remember it's different to legal ownership. We have a legal ownership where you have your, let's say, your subsidiary registration document. There you will see directors, and that is also part of your legal ownership, directors, shareholders, and that type of thing, right? Beneficial ownership goes deeper, because legal ownership is just that one entity, where beneficial ownership goes further into the structure, further into the mind map. Let's say we have a mind map where we're now saying, okay, company A is owned by company B, who's owned by the trust. Trust as trustees, we come from company C, that type of thing. That's beneficial owner. You follow the line, the structure, the map. Okay, so like I said, there's a difference between the two. And it's also the legal owner may not always be the beneficial owner. Very important to remember that as well. So when you are doing your beneficial ownership investigation or research, you are not going to look at the SIPC document and be oh, the directors, they are the beneficial owners. You actually need to ask more questions from your clients in order to find out who the beneficial owner is and to fulfill that obligation in terms of the Act. Okay, so this is just a portion from the Act which I have taken out. I think this is a nice highlight on what the requirement is. So in the Act, it mentions that a beneficial owner, or you need to identify and verify people with who indirectly or indirectly ultimately owns or exercises effective control of a client of an accountable institution or a legal person, partnership, or trust that owns or exercises effective control of, as the case may be, a client of an accountable institution, or they exercise control of a client of an accountable institution on whose behalf a transaction is being conducted. Also includes, in respect of legal person, each natural person as contemplated in section 21B2A, a partnership. In a partnership, each natural person contemplated in 21B3B, and for a trust, each natural person contemplated in 21B for C, D, and E. So those are very important aspects of the section. You need to, when it comes to legal persons, the guidance is there. It's in the Act. You need to identify your beneficial owners of your legal persons. Your partnership is all your partners, and a trust is everybody in the trust. So we look at your trustees, your beneficiaries, a founder, donor, everybody to a trust. You will see it is all listed in the Act who needs to be identified and verified. Remember, 21B is about identifying clients. So identifying your beneficial owners who must be identified and verified when you have a legal person as a client, a partnership, or a trust. Okay, when we look at how do we go about identifying, or we got a client now, how do we go about finding out who the beneficial owner is of our client? It's important to remember that we have different types of clients. You've got, for instance, your legal persons, you've got your private companies, you've got your closed corporations, you've got public companies, different types of legal persons, and they have different features, right? So you have directors sometimes who are, the first part of a company or legal person. You've got members, you've got nominee directors sometimes. So you need to know what type of client am I dealing with, so you know who you need to go identify and verify. So a private company has a shareholding. From the shareholders, who has the percentages? Who am I looking at when we need to fulfill this obligation? So it's important to first take a look at what type of client am I dealing with? How was this client created? How was the entity created? You might say, okay, a legal person, they go to SIPC to go register their company. That is how they created, with all their shareholding and directors and so forth. A trust, they must go to the master's office. They must go register at the master's office, the trust, that type of thing. So how was this entity created? Now we know who is involved and what kind of documents we need to obtain from the clients. And how do we obtain that information? So you need to know how you must obtain that information. We have some clients who do their own mind maps. They ask the clients the questions and they draw a mind map to identify clients. We have other clients who have discussions with their clients. So what are you going to do to obtain the necessary information so you can identify or establish who the beneficial owners are of your clients? Every institution is different. Every institution knows their clients. It is not a one size fits all. You must do what fits into your processes and what is your risk tolerance as well. That is a very important question to ask yourself. Am I willing to go this far? Am I willing to go that far? If not, what can I do as an alternative? Because the requirement must still be met. So how do I obtain the relevant information for me to establish beneficial ownership? You need to know the type of possible beneficial owners. So PCC 59 has a nice table of who is regarded as a beneficial owner in your different types of entities. So you can just have a look over there. And then we need to identify the money laundering, terrorist financing, and proliferation financing risks posed for those type of entities. With the latest national risk assessment, they highlighted that MPOs are a higher risk organization or entity based on international findings, local findings. So, for instance, when we say identify your money laundering, terrorist financing, and proliferation financing risks, that's a type of entity that could pose a higher risk for your entity. So, what are you going to do as part of your due diligence to make sure that you are covering all your bases? Look, we don't treat any clients with any prejudice, but we need to make sure that we are following the risk-based approach. So what you do for the organization must be best for your organization. So now that we know how we go about this, what do we need to do? We need to identify beneficial owners. So in your CDD processes, you might your first step is going to one of the first steps is going to be identifying your clients, and that is where you obtain ID documentations, other documentations that you require for those steps in your CDD processes. And it's no different to when it comes to your legal clients or trusts or partnerships. You need to identify the entity. You need to identify the legal person, the trust, and the partnership. So what documents, when I said manner in which the entity was created and how to obtain the relevant information, that is where you would link that one of the entity. What document do you need to receive? What do you need to do in your processes to identify this legal person to make sure that it's registered, it is valid, it is active, all of those items. So you need to identify the legal person, trust, or partnership. You need to identify the persons acting on behalf of the legal person, trust, or partnership. It would be so easy, and maybe with AI, if I can just tell my company A, go purchase a property for me, and some AI in the wind goes and does that. But we live in the real world. Someone is always acting on behalf of the company, whether it's a director or another representative of a company. So who is the person that's acting on behalf of this entity? That person must also be identified. And remember, the requirement doesn't stop just by identifying. Identifying is the broader aspect, but in that, you have your different other requirements that needs to be filled to make sure that everything is above board with this client and the person that's acting on behalf of the client and the beneficial owners. So you need to identify each beneficial owner of your client as well. So your CDD processes must apply to each beneficial owner as well. For instance, when it comes to identifying your clients, what are the processes in place for a natural person? The same will be that will apply to your beneficial owners. It's very important that the manner and process which additional due diligence, that is what Section 21B refers to. It's known as additional due diligence. So this process must be stipulated in your RMCP. It must be clearly stipulated, and not just in your RMCP, you must be fulfilling that obligation in your transactions as well. So whatever you're saying in your RMCP, that must be done realistically in your processes, in your operations. When we come to an impact, we look at the impact it has on a business. You need to identify and verify your beneficial owners. So you need to make sure that you have from point A to point Z, let's say, you need to make sure that you have identified correctly. So you start with, let's say, your mind map. You've now identified who beneficial owners are. You've identified and verified your clients. Your RMCP, whatever it stipulates, if it stipulates that, you need to make sure that for every client, that is what you're doing. The FEEC has advised also that when it comes to identifying and verifying your client, that there is flexibility. So you can do what you feel your organization can, whatever capacity they have, to identify and verify your clients. There is no set rule on what needs to be done. You just need to make sure that the obligation, the requirement is being fulfilled, which is identify and verify. So you might be telling me, Kaylin, that's all good and well. We understand this is a requirement. How do we go about fulfilling this requirement? What if it is such a complex structure? We don't know where to start. We've got all these names of all these companies flying around. What do we do? What if we get a simple company? What do we do? So PCC nicely outlines the process of elimination, PCC 59. They say the first step, when you have a client that comes to you, they now want to purchase a property from you. You need to first and foremost identify the person who has a controlling ownership or ownership structure of the client. So is there anyone, can we identify a natural person who has controlling ownership interest? No? Okay, now we go to the second level. We identify the natural person who exercises control by other means, including through his or her ownership or control of other legal persons, partnerships, or trust. So you might have your client who, as a shareholder who is another legal person. We are now looking further deeper into that other entity to see does my beneficial owner lay there. If not, if you cannot identify a natural person in that step, in the second step, then you're going to go to the third step, which is natural persons who exercises control over the management of the legal person. Because that person in management, like your executive officers, might have actually quite an influence on your client and therefore is in a position to be a beneficial owner. So that is also an important step. If you cannot identify your beneficial or establish your beneficial owner in step 1 or 2. Okay, I'm just going to go a bit more in depth into these processes the process of elimination. So this is the example now for your legal person. So your step 1, controlling ownership interest. So that is your client, company A. You need to now identify who are the natural persons that has controlling ownership interest of my client, who is the human being, the warm body behind my client or bodies. Okay, we need to look at the center's view of the definition. So the FEEC has their own definition on who a natural person is with controlling ownership interest, and that is the definition that we need to follow. We look at the percentage of ownership interest and reference to the level of influence or control. You'll find in these companies where there's a simple layer, you just have your natural persons as shareholders, that they normally have big shareholding, 100%, 80%, 50%, even 50-50. So they both would have, let's say it's 50-50, they both would have a big level of influence or control. They have the last say in what happens within that entity, within your client. So a bigger portion may lead to showing that that person has a bigger level of influence or control. Always just good to keep that at the back of the mind and to see if it is relevant to your case. The FEEC has advised that we need to take a hybrid approach. So this is where we look at the threshold, which is 5%, the threshold approach, and an overall assessment of ownership influence. right? That is the look-through approach. Who are all our beneficial owners or shareholders, for instance? 5%. It used to be 25%. The FEEC has strongly recommended or advised that we need to follow the 5% rule. There are many reasons for this, including the trends that they have found where criminals had very small percentages of ownership or beneficial ownership in these entities which were conducting illegal activities. That is one of the reasons. The other reason is also international trends. So the FATF has also given the recommendation of 5%. So we're no longer looking at our shareholders, for instance, who has 25% shareholding in the client. We are looking at anyone who has 5% or more. So it doesn't stop at the 5%. It may take you a bit further into, okay, so 3 levels down, I have someone who has 5%, let's say 50% of that entity 3 levels down. But if you look through the shareholding, through the line, we will see that that person at the end of the day actually has 20% shareholding in my client, which is more than 5%. So even though they're 3 levels down, we've calculated and see that they actually have more than 5%, 5% or more shareholding in my client. So just because they have 50% there, doesn't mean that they're not going to have 5% in my client, because obviously it gets smaller as we go up, but you just never know. That's why calculations are important to see, does my client or does that person have 5% shareholding in my client? So that is step 1. Identify your beneficial owners who has 5% more ownership in your client. So not just in your client, through your client. Step 2 is exercises control through other means. So there are various ways to exercise effective control. So we spoke about control in interest in another company who is perhaps a shareholder of your client, but it can also include people with power of attorneys, your nominee shareholders, your nominee directors. They can also be beneficial owner by exercising control through those means. So it is broader, and we need to look at the whole, how everyone who can hold or control, exercise control through other means. So those are just some examples of how it can be done. And then step 3. So remember, step 1, cannot identify. Step 2, still cannot identify who the beneficial ownership, who the beneficial owner is. I'm going to step 3. This is the person or persons who exercises control over the management. So this must not be the first step that you go to. Just because it might be easy, you should not go to this step first. You need to go step 1, step 2, follow the process of elimination. Very important, highlighted word. Okay. And it's only applied in exceptional cases where you would go to number 3. This may include, but is not limited to, your executive officers, your non-executive director, independent non-executive directors, director, or managers. And if you look at guidance note 7, well, 7A now, sorry, I forgot the A, you will see what the definition is of effective control. What does it mean to have effective control of a entity or a client? When we look at beneficial ownership information, we look at who, why, and how. Who are the beneficial owners? Why are they the beneficial owners, and how? This is good just to think about when you are doing your processes, going through your processes. It's important that your information is adequate, accurate, and up to date. Also remember, Section 21E of FECA. When you are unable to identify and verify clients, you must not continue transacting with that client. That goes the same for beneficial ownership. If you cannot identify or verify the client, you may not continue with the transaction. Any of your beneficial owners on the TFS list cannot. We know that that is a requirement, or it's in the act that you cannot continue. And then also when you have your clients and you're looking at beneficial ownership, if you see that your client is involved in public procurement, you are cautioned to treat it as a high-risk client because of international trends, local trends of corruption that occurs. So just also important to keep that in mind. You might ask me, so Kayleen, I'm a candidate property practitioner. Why is this important for me? This is important for everybody in an estate agency, your candidates, your non-principals, your principals. Everybody should know beneficial ownership to some extent. So if you look at the candidate, it's important to know the basics, to learn the basics, and to apply additional due diligence when you are busy with clients. So this gives you a nice preparation to when you are dealing with a client who is a company. Your non-principals, same as candidate. When you are a candidate, now become a non-principal to implement and assist with implementation of compliance procedures daily. So you can assist your principal, you can assist candidates to make sure that they are doing what they need to do. If it is a task within the company. Obviously, every company is different, and also escalate complex ownership structures. If you don't know what is the next step, always go one step higher to your principal for assistance. And then we got our principal and business property practitioners. Always know that they are accountable for firm-wide compliance, and they need to ensure that systems training and they are audit ready for a possible inspection from the FEEC. If we go down to an illustration now, this is just a practical example of how this natural person 1 has beneficial ownership of legal entity 1. You will see legal entity 1, that is your client. They're owned by another legal entity and other individuals as minority shareholding. Legal entity 2 has majority shareholding. And through entity 2, you see it goes down all the way down to natural person 1, who has 50% shareholding, the majority shareholder of legal entity 5. So now we've got to the last warm bodies. He's got 51% shareholding. You'll see under natural person 1, there's a calculation. We need to now see through the line how much percentage natural person 1 has of legal entity 1. So over here, he has 3.5% shareholding through the calculations, through ownership in each entity. He is a beneficial owner as he is majority, even though there's a 5% threshold. But you will see there is a lot of other minority individuals who have very, very small shareholding at the end of the day in legal entity 1. So natural person 1 is a beneficial owner of legal entity 1. So this is like a type of mind map that you can do when you are busy with your beneficial ownership. Because beneficial ownership can be a bit complicated at times, we have found that clients or accountable institutions are doing as far as they want to based on the risk rating of the client. Low risk, we are only going to go to the directors, for instance. It's very important, it's a rule. You must identify beneficial owners, not based on the risk rating that the client was assigned. You need to, we also found that it's the same thing from following on from the point before. Accountable institutions stop at the first layer of ownership. Accountable institutions, some of them assume the person signing the mandate is the beneficial owner. They treat beneficial ownership as a once-off, especially when it comes to business relationships. Ongoing due diligence must be done, and things do change in those circumstances. And weak documentation, regulators have seen that the documents for evidence is not as fulfilled as it should be. It is not sufficient as it should be. Okay, I'm just going to go through 2 case studies quickly, just to give you an example of what the outcomes could be if you do not comply. So we have seen that the FEEC has been conducting enforcement action. They conduct inspections on property practitioners and other accountable institutions, many have failed to properly identify and verify beneficial owners of their clients, who are companies and trust. And they found that a lot of them stopped at the first layer by the directors, for instance, and not go through the process of elimination. The outcomes in some of these inspections, some received administrative sanctions, and it included financial penalties. Some were directed to remediate client files, and others were the peak emphasized that failure to comply with Section 21B undermines South Africa's FATF commitments and exposes the property sector to money laundering. So we all know that the property sector is a bit of a higher risk industry, and failure to comply with Section 21B does not help in that case. This case study is a scenario on how a firm, a property practitioner firm, can be misused. So we have a property practitioner firm who is mandated to sell a luxury home. They have a buyer who is a company registered within South Africa. The firm only records the company's director as the client and does not check who actually owns the company. So he's got the documents. He says, okay, director, we are only going to go and identify you. What is really happening? The company that the client who is a company, is actually controlled by another entity overseas through shareholding. The ultimate beneficial owner of that company, of the client, is a politically exposed person under investigation for corruption, trying to hide illicit funds by purchasing property. Because the firm didn't trace ownership, they didn't go further and find out who the beneficial owner is of their client. It unknowingly facilitated money laundering. Not so good. What are the consequences that this firm would face? So regulatory penalties, massive fines, possibly reputational damage, and operational disruption if they are forced to redo all of their clients' files. So there are definitely consequences, and it can be severe based on your level of compliance. So on that note, that is the end of my presentation. We at Moonstone are always willing to help. We are there to help accountable institutions, and we actually have a health check, which you can complete. It is a set of questions so that we can identify or see the level of compliance. How compliant are you? What is your compliance status with the Act? So we've actually compiled a health check, which is, like I said, a set of questions you can complete. The link will be posted on the webinar for you to click. All you need to do is click on the link and you can get to the questionnaire. The questionnaire is to help us identify your compliance status and give you feedback on your compliance check. So it's like, going to a doctor. You're going to a doctor because something's not going right, and you need to go to the doctor to see what is wrong. So this is us just looking to see where you stand in your health check of your FICA framework. So we are willing to assist. You are more than welcome to click on the link to answer the questions, and we will get back to you. Thank you very much for your time, and thank you, Naledi.
Thank you, Kayleen, for the presentation. Very informative. We are now going to our second speaker, Daly. Please flag for us the presentation, then we will be followed by questions. Colleagues, I want to say that I've put the link on the chat if you want to go through it. Let me wait for Daly to flag. It could be her network.
Naledi, it's not showing. Okay, let me just...
Not yet.
I'm not... Okay, let me start afresh and see if I can...
The hands, we can see them.
Is it showing now?
I'll tell you, not yet. Maybe it's still loading. Let's give it a minute.
Okay, let me stop sharing again and try. I'm not sure what's happening. See. Can you see it?
No, let me just come there quickly. Colleagues, give us a minute.
But mine says sharing.
Really?
Let's see. Stop sharing and try again. Let's see.
Where's your Teams? Nomfundo, can you see our screen?
I can see the screen.
Thank you.
Okay, I'll just wait for Naledi to see if she can see it. But colleagues, are you able to see my screen?
Can we see the thumbs up if you can see Deli's slides? It could be my system on my side. Okay, Deli, Kaylin can see your slides. I think we can continue. I'll just monitor the chats. Let's continue. Thank you.
Okay, all right. And thank you, Naledi. Thank you to also Kaylin for the presentation. That was really beneficial to some of us. Just to understand who is a beneficial owner. But thank you to everyone today. And my presentation will just recap on many of the things that I suppose we as property practitioner already know. And the purpose for us to recap is that we intend to present section 68, and we would like property practitioners to participate in terms of the process going forward. But I thought just to present only that would not make sense. So let's just recap first, and then we'll get to what we really want as a PPRA, or what we seek to ask the industry to assist us with. So some of the, when we look at contracts in particular, if you look at section 68, it speaks about agreements. So when we look at contracts have got key guidelines and essential elements. And one of these key essential elements is that we must have or the contract must clearly identify the parties to the agreement. And this means that we must include their full names, their ID numbers. And for example, if the party is a legal entity, such as a company or a trust, then we must have the registration number included in the contract. Also key to a contract is having a comprehensive description of the property that we are selling. And this includes specifically including the address of the property. And it's also important, colleagues, that we include the title deed number and any other relevant information about the property size and boundaries. I know that sometimes we get complaints where those issues are not specified in the contract. If you're not able to specify it in the contract, you can ask the seller if he can give you a copy so that you can give those details to the buyer. We also, in contracts, you must also have the purchase price. All agreements must specify how much is the property. If there are any deposit amounts that are payable, they should be stated. If there is the payment terms must also be clearly stated, and state whether that payment is in cash or whether it's subject to a bond approval, and also the dates on which those payments must be made is also important to be included in the contract. Key to some of those elements is putting in or stating the date of occupation and when the risk of transfer is. We also, in that mix, also include the conveyancing attorney's details so that the consumer or the purchaser knows who the conveyancing attorneys are. And important also is that that contract must have signatures and formalities to ensure that all parties sign the documents. As we know, verbal agreements for land are invalid. Contracts also have what we call critical considerations, and these critical considerations include your suspensive conditions. So suspensive conditions must state whether this property is subject to a bond approval or subject to the sale of another property. And these suspensive conditions are really important because then they speak to when the contract becomes effective. And when we then go to properties that are below the amount of 250,000, we need to have a cooling off period. And this cooling off period in terms of the statute is it's 5 days. So we must also have clauses that speak to your breach. This basically defines the consequences of what happens where one of the parties failed to meet their obligations. And key also to this critical consideration is just including or outlining the process of transfer of the ownership, including the date, and also, specify the costs that are associated, for example, your transfer costs, the legal costs, and other related costs that might be included. And I think this specifically avoids disputes in the future when clients now start complaining that they were not aware that they're supposed to pay such costs. And then also, we must speak, the contract must contain the transfer of ownership. When will the buyer take occupation of the property? It should clearly state whether the buyer can occupy the property immediately or whether the buyer will take occupation of the property, whether on the date of transfer or in any specified date that is agreed upon. We also have to include, for example, dispute resolution, which then helps us when there is a dispute. If we have included that clause, then we are able to invoke, if, for example, the contract speaks to mediation and arbitration before we go to a full-blown, legal case, court case, we can then exercise the mediation and arbitration processes prior, which are usually cheaper and less costly than court proceedings. And also critical is that for a sale agreement to be legally binding, it must be signed by all parties involved. And in South Africa, the signatures of both the sellers and the buyers are important. That is why when you look at the Alienation of Land Act, it clearly provides that for an agreement to be legally binding and enforceable, then it must be physically signed by both seller and purchasers. So now we know that we mostly use electronic communication, but please note that sale agreements cannot be electronically signed. That's one of the exceptions of when it comes to sale agreements, we cannot have an agreement that is electronically signed. And also, just to emphasize compliance with the Alienation of Land Act, let's look at a case that happened I think the case was decided in November 2025. It's a recent case. It is the Eastern Cape Development Corporation versus Dlamini. And what happened in that case is that the court confirmed that an unsigned deed of sale is invalid. In fact, it's invalid from the outset and it cannot be enforced. To the extent that even if the buyer has occupied the property for many years or made payments in respect of the property, this agreement remains invalid because there is no signature. So the background of the case is as follows, colleagues. It's that the respondent had signed an agreement with the Eastern Cape Development more than 20 years ago, and they occupied the property. So according to them, they claim to have purchased the property from ECD and ECDC, which is the Eastern Cape Development, and they relied on an agreement that they had in their possession. And in complying with the terms of the sale agreement, they had then made two payments, one for 240,000, and then they made another payment for 340,000. And they considered these installments as part of payments towards the purchase price. However, when a dispute then arose between themselves and ECD then argued that, in fact, the 340,000 that had been paid by Dlamini was not in respect of the purchase price, but was in respect of halting eviction proceedings. So what happened is that when the dispute started, after they had paid 240,000. When the dispute started, then Dlamini paid an amount of 340,000, and he believed that he was paying this as part of the purchase price. But what ECD said is that no, it was actually not part of the purchase price, that it was basically part of payment to hold an eviction. They also argued that the deed of sale was actually never signed by them, or it was also never signed by their authorized representative, and further that the property was never legally transferred. So because of this dispute then, the Eastern Cape Development wanted to sell the property. In 2023, the respondents then approached the magistrate court for an agent interdict, trying to stop the auctioning of the property from going ahead. And luckily for them, the magistrate court granted an interim relief and later issued a final interdict, against ECDC. But ECDC did not take that ruling, and they appealed the ruling, and they were successful. And here's why they were successful. The court said in that case, a sale agreement must be signed by both parties, and that this is a requirement in terms of Section 2, subsection 1 of the Land of Alienation Act, which requires that sale agreements not only be in writing, but that they are also signed by both parties and their authorized agents. So the court found that the agreement between the respondents and the Eastern Cape Development lacked the ECDC signature and therefore rendered it invalid from the start, and ruled that without a valid contract, then no rights of transfer could have arisen. The court colleagues went on to observe that the payments that were even made by Dlamini could not validate a void contract, even if the respondents believed that they were paying this money towards a purchase price. In fact, the court went on to state that the long-term occupation by Dlamini did not create ownership rights, that the occupation for 20 years did not in any way establish a clear right for a final interdict, and that ownership cannot arise by mere occupation. So basically, Dlamini lost the case, and the High Court set the magistrate court decision aside and therefore dismissed Dlamini's application. So ladies and gentlemen, there are key lessons that emerge from this case for both buyers and sellers, and which we as experts should always try and advise, sellers and buyers to make sure that the formalities of a contract are fully adhered to. Firstly, I think the key lesson here is that no signature, no sale, an unauthorized deed of sale is legally invalid from the start if there is no signature. And secondly, another lesson is that making payments to a contract that is not signed does not cure a defective contract. Thirdly, occupying a property cannot validate an unsigned agreement. So those are the lessons that we will learn from this court case. But I think importantly, colleagues, today, as the PPRA, having given a recap of agreements, which I assume we all know, Section 68 says that, in particular, subsection 2 says that the authority must publish from time to time an updated version of guideline agreements on its website. So as the PPRA, since the enactment of the Act, this has not happened. And it is this that we now want to engage on and try and develop guidelines in line with the Act. And maybe before we even discuss the process that we want to follow, I should just state that this has been necessitated mainly due to the many complaints that we've received as an investigation team. And some of the complaints that have arisen include, for example, the lack of a clause. So we as property practitioners, obviously in the contracts, we put a clause for commission, but sometimes we fail to state that this commission includes VAT. And consumers then lodge complaints against property practitioner when they then see the invoice where the commission now includes VAT. We all know, however, colleagues, obviously consumers will say they didn't know. We all know that commission payments are generally considered a standard rated supply of services, meaning that they include VAT, 15% VAT. So if an agent is registered VAT vendor in South Africa, then they are entitled by law to charge VAT. But obviously, with consumers, if they don't see it in the contract, then they start arguing that, the property practitioner failed to disclose that they were going to charge VAT. So these are the issues that we now want to see if we can deal with in terms of guidelines. Another example that I would give would relate to property practitioner, for example, failing to state in the contract the name of an agent who concluded the agreement. I should state, colleagues, that failing to include the name of a property practitioner in an offer to purchase is common, yet serious omission in real estate transaction. While buyers and sellers, while it does not necessarily invalidate the entire contract, we know that between the buyer and the seller. However, it can lead to significant, commission disputes and legal complications and the difficulties in identifying the effective and the person who was the effective cause of the sale. So these are some of the problems, and there are quite a lot that we've come across when it comes to contracts and previously, before the enactment of the Act, was the one of disclosures. But now that has been cured by the requirement that every offer to purchase, in fact, your mandate, you must make sure that there is a mandatory disclosure form. So, colleagues, so these guidelines that we are seeking to develop will serve as a framework of recommendation. They will serve as best practices and are really designed to provide clarity and provide some direction. And just to ensure that there is consistency going forward when we draft contracts. So what we are then going to do is we're going to request property practitioners to make submissions to these guidelines. And once we receive those submissions, then we will go ahead and have draft guidelines, which will then go through the process. Once they are approved, they will then be adopted as guidelines in terms of Section 68. So for the PPRA, we saw it fit that before we can even do any draft, maybe doing a draft based on the complaints, let's take it out to the industry. Let the industry make submission as to some of the guidelines that they would like to see on offer to purchases. Please do remember that these guidelines will not bind the seller and the buyer, but these guidelines will obviously be guidelines for property practitioners only. And I think what we will do is that we have a list of all the property practitioners that are on today. And we will also bulk email to all the property practitioners that we have on our database and request them to make submissions to these guidelines. So that is all from me, colleagues. It's just to say we are embarking on this process, and in embarking on this process, we want participation or request participation of the industry, because at the end of the day, the industry will be the ones that will have to deal with this guideline. So as a PPRA, we cannot develop any guidelines without a consultative process or a process that includes property practitioners. So thank you, colleagues. That is the end of my presentation, and those are my details if you want to find out anything further regarding my presentation. Thank you, Naledi, and thank you to everyone.
Thank you. Thank you, Daly, so much for the presentation today. We're now going to go to the question. I have a question on the chat, Daly. I'm going to also allow the hands, Kaylin, so that we can engage with our stakeholders and practitioners. I have a question from Nicolene. How would the outcome of that case be applied to rental agreements, Daly?
I think with the rent, remember that in terms of a contract, you can have a verbal contract with parties can have a verbal contract, and the courts have always acknowledged verbal contract, especially when certain actions have been taken in fulfilling that verbal contract. But we know that when a statute provides otherwise, so for example, with sale agreements, the statute does not allow verbal contract. Instead, it requires written, signed agreement. But with lease agreements, you can get away with having a verbal agreement based on the fact that there was payment, there were terms agreed upon, and whatever action that would have been taken. But it is important that you do have, a signed lease agreement, simply to avoid any problems in the future.
Thank you for that. Let me mute Tembo. I'm going to mute you. Sorry about that, colleagues. Let's mute while we are getting the answers and while other colleagues are asking their questions so that we can all get a chance. Let me go to the hands. Adrian, please unmute yourself and let's hear your question. Who is it directed to? Please unmute. Adrian? Okay, let's go to Sophia. Please unmute. Sophia?
Hello, sorry.
I will come to you. I'm going through the hands. We will come to you. Yes.
Okay, now, thank you.
Let's go to Vanessa, because 1 and 2 can't unmute. Let's try Vanessa. Please unmute. Colleagues, can you hear me? Vanessa, please unmute and ask your question. We can see your hand. Okay, they're not winning. Maybe it's network. Vanessa?
Hello.
Yes, please ask your question.
I'm so sorry. It was a mistake to press the raise hand. Sorry
Okay.
about that.
All right, no problem. Let's go to Cass. Cass, please ask your question. Okay, we'll come back to you. Let's go to Yvonne.
Hi, Naledi. I think most of the hand raises were in the beginning when we didn't have the screen that was working. But nevertheless, I do have a question for Daly. So Daly mentioned that for a sales agreement, it might not be signed electronically. I did mention it in the chat box as well. So what happens if you have a seller that does not reside in South Africa anymore and you have to sell a property? I mean, the only way that seller can sign is electronically. So does that make the contract not valid then?
I think there's a difference between sending the documents electronically and signing electronically. I think that's what the Act differentiates. So if you read and if you read the Electronic Communications and Transaction Act, it does state that you can't sign a sale agreement electronically. So which means your clients must have that document printed and they must sign it, physically sign it. It's different from sending it electronically than signing electronically. I'm not sure whether you understand the difference. So sending it electronically, you can. But remember, some conveyancing attorneys, for purposes of transfer, will then require the original copy, where you can then obviously ask your seller or whoever to send it via courier. Some of them, what they do, the conveyancing attorney, they require it to be signed before a notarial, especially if it's not in the country. They will ask you to go to a notarial in the country in which you are and have it signed and then sent back. So there's a difference between sending it electronically and signing it electronically.
Okay. Yvonne, does it cover your question?
Yes, thank you so much.
Okay, and I think also, with sometimes, with the signing electronically, people type their signatures, and you can see that this one, it was typed out, using the fonts that we have on the Microsoft. I have maybe like a comment for Kayleen from Bailey. Please go back to the slide of beneficial owner. I think they need clarity on that, Kayleen.
I know, ladies, sorry, which slide specifically?
They are not mentioning, they only say beneficial owner, maybe in the beginning. Billy, can I ask that you
The
come through,
first
you
one.
clarify?
Okay, I'll share my screen in the meantime.
Okay. Let me go and see if Billy didn't raise a hand. Okay, he's number 5. Okay, Kayleen is number 5. Maybe we'll touch on that while you look for the slides. We'll come back to you, Kayleen,
Okay.
with Billy. Let's go to Pine. Please ask your question.
Sorry, it was in the beginning. Just do.
Okay, Chantal.
I'm fine.
Chantal, please ask. Okay, maybe also that. Val. Val, you can unmute and ask your question. Okay, false alarm. Billy, please clarify which slide must Kayleen go back to?
No, it's okay. I managed to get the notes from you.
Sorry, I can't hear you.
I managed to get the notes from the slide.
You're still checking the notes.
Yeah, no, I got it already. Because the
Oh,
hand was
okay.
raised. Thank you.
Oh,
Is it
okay.
sorted?
I think he's
Yes, it's
covered.
sorted.
Yeah.
Okay,
Yeah,
thank
thank you.
Okay, Melika, please ask your question.
Thank you and morning, colleagues. I just wanted to double check, right? If my memory serves me well, in law of contracts, there's tacit agreements, right? Now, this is speaking to the issue of selling and all of that. So are we saying, based on what now has been presented to us, that there has to be a signed contract as far as selling is concerned? Now, are we therefore saying any tacit agreement will be done away with? It's just clarity from my end. For instance, I mean, in a situation where hypothetically somebody wants to purchase a property, let it even be residential, and there's some kind of a tacit agreement to say, no, you can move in or whatever in the meantime, whilst we finalize the sale agreement and all of those things. Are we doing away with tacit side of these agreements? Is that what we're saying? So if it's not signed in black and white and physically signed, therefore no any other, I don't even want to say ambiguous, but no any other agreement outside of that document then suffices. Is that what we are saying now? Just for clarity from that point.
Thank you for the
Thanks.
question, Deli.
I think, Naledi, it's not us that is saying that, it's the legislation. If you read the Land Alienation Act, it's clear that if it's a sale agreement, it must be in writing, it must be signed. So it's not really us. I know the issue of tacit agreements, and I think the courts have, in many cases, held that tacit agreements are valid. But when it comes to immovable property, that's what it requires. You can have tacit agreements when it comes to any other agreement, but when it comes to sale agreements, this is what the legislation says. Hence, I read a case that was recently decided in 2025, where the agreement had been in writing, but it didn't comply with one of the requirements, which it must be in writing and must be signed by all the parties. And we have seen that the courts are now and recently are moving to implement this particular, they have been implementing this particular legislation that says, you know what, your agreements must be signed. So for purposes of sale agreements, colleagues, it must be signed. That's what the statute said. It must be in writing, it must be signed. Tacit agreements, valid, but for purposes of immovable property, you're definitely going to have issues as presented by the case that I cited.
Thank you. Does it answer your question? Let me go to the other hand. Faith, please unmute. Faith. Okay. Faith is not winning. Let me see if we have more questions on the chat. Yes, we are going to share the slides, and the recorder is going to be on our PPRA TV. We're going to share that as well. Okay, let me see the Q&A so that I don't disadvantage anyone. Faith, do you still want to unmute before we can close our webinar? We don't have any more questions. I think the presentations were straightforward, and because we're going to share for, a continuous reading from our side, maybe before we can close, Kayleen, do you want to maybe just highlight and say a word before? But I see a hand maybe before I close the webinar. Let's go to Yeni. Please unmute. Jenny. Okay, maybe they're struggling with the network because these are the new hands that we are receiving now. Melika?
Thank you, Naledi. Sorry, and I do, please do pardon my little bit of misunderstanding on this part, but nonetheless, maybe I can get clarity and better assistance, right? Now, looking at state-owned companies when it comes to this beneficiary side of things, how does that play out exactly for a state-owned company that owns various properties, etc., etc.? Like, what would be an ideal scenario in that? Just for extra clarity on my end. Thanks.
I think that question is for me. So when it comes to state-owned entities or organs of state, you still have to identify who the beneficial owners are. You can follow the 3 steps or the process of elimination. While there's no controlling ownership interest in an organ of state or state-owned entities, you would then go to the next levels and then find out in those step 2, what does legislation say about that type of entity, state-owned entity that was formed? What does it say? Who are the authorities in those entities? What are your levels? Like, I mean, if you look at a municipality, for instance, you know, you've got different levels of management, authorities. So that would be your second step, essentially. And then when it comes to your third, if you're still unsure there because you cannot identify who they are, you would then go to your management in those entities. So still, your CDD still has to be done on state-owned entities, and you would just look at those type of levels, your levels of authority, management. That is where you would go in those type of entities. I hope that helps.
Thank you so much for that. Let me go to Mavis. Mavis? Mavis?
Good morning, everyone. We joined as a team. One of our colleagues will ask the question.
Hello.
Hello.
Hi. Yeah, my question is regarding the beneficiary ownership. So in practice, how far are we expected to trace the ownership layers, you know, in order to identify the natural person?
Thank you, Kaylin.
Yes, thank you for your question. So that is where the process of elimination comes in. When you look at your first step, if you cannot see a clear human being, natural person who has shareholding or is a member, controlling member, that type of thing of your client, you would then go to step 2, because now you've seen, you know, there's in other entities who is shareholders in your client. So the best way to start is to ask your client, you know, to give you more information on the structure of the ownership. Once you get that information, you can kind of see, you know, how far you need to go. When it is unclear, you know, who the beneficial owner is, because you can see all these people, all these entities, and you cannot distinguish who the beneficial owner is. That is when you would then go to your step 3, for instance. You know, you would look at your management. So you need to, as far as possible, and evidence also that you have done this, just draw a mind map for yourself. You know, have your client as the first part, and then from there, see who else is connected to your client. Who are those people? If you cannot identify, go to the next step. If the client is being a bit difficult, I know it's not an easy thing sometimes, this is a requirement. But you don't have to always go to the last warm body if you cannot see who the beneficial owner is, who the shareholder is. You go to the last warm body in terms of beneficial ownership, and that could be in your step 3. So I know there is a lot of confusion out there as to how far you must go. But as long as you follow the process of elimination and you evidence that you have followed the process of elimination, step 1, step 2, step 3, that is your requirement fulfilled. Obviously, it also has to be what your company has implemented through the RMCP as well. I hope that helps.
Thank you for that. Kaylin, maybe while you're on the floor, Serena says, what is the time frame for FICA to update their legislation to show accountable institutions as including all property practitioners rather than only estate. Okay, let me load more. I'm going down. Estate agents. When will managing agents need to plan to have their RMCP in place, etc.?
Okay, so yes, at the moment, the item 3 to Schedule 1 of FICA only refers to estate agents as defined in the Estate Agency Affairs Act. So right now, it doesn't extend to other types of property practitioners in terms of the PPA. We don't know what the time frame is. We don't have any idea that they haven't given any information regarding the other types of property practitioners. Unfortunately, I'm not able to answer on the time frame. That is maybe where the PPRA and the FIC maybe need to have discussions around that requirement for other types of property practitioners. With regards to implementing an RMCP, it would be considered best practice to prepare yourself for the event where the other types of property practitioners will be included in the item 3. So it all depends on your risk management. Do you want to wait till the last minute when they now say, okay, you are now an accountable institution, you need to implement the act, you need to comply with the act, and now you are going to be doing everything that you need to do? Or do you want to start getting into the operational aspects of it now? Do you want to find out, what is needed, what is the requirements? We can also assist there, to advise, what is FICA all about. So it all depends on your organization, but I suppose it would be considered best practice if you start getting familiar with the requirements and what an RMCP is.
Okay, thank you so much. There's a question for Delhi from Denise. Delhi, must a mandate have a price inserted and be signed in full, or do initials suffice?
So, Naledi, it says, must a mandate be, yes, a mandate must be signed. Remember, it must definitely, your agreements, colleagues, must be signed. Mandates must be signed. It will avoid disputes for you and the seller in the future that he didn't sign the agreement. So it definitely has to be signed. You can include the purchase price, but I really don't think that it affects its validity, as long as the seller will tell you how much he wants. And when he does, when you do draft the sale agreement will then provide for the amount that the seller is looking for, or whatever amounts that you have discussed with your seller. But when it comes to mandate, yes, the mandate must definitely be signed. Whether it should have the sale agreement, it should have the purchase price, not really. But if you wish to have it, then you can have it. All that is important that you should not forget is that your mandates must then have your mandatory disclosure form. Yes, your mandates can be signed electronically. They can be signed electronically. That's acceptable. Remember, we are dealing with a statute that says for sale agreements, long-term leases over 10 years, no electronic signature. So electronic signature, when you read the Electronic Communications Act, they are valid, but there are these exceptions that then come in when it comes to other agreements. So mandates is not part of those, does not fall part of those exceptions, so it can be electronically signed.
Okay, so Denise, I think maybe it answers to say initials, do initials suffice? So Denise, it does cover your question to say, please,
not initials,
let's have
it
the
must
signature.
have full signatures. Yeah.
Yes, yeah. Okay, let's go to the hands. Mavis, please unmute.
And all owners must sign. All the owners, not one. Every owner.
Oh, okay. Thank you for that. Mavis, please unmute. Okay, let's go to Jenny.
No,
Okay,
I'm done.
maybe.
I'm done. We did ask
Oh,
the
okay.
question. Thanks.
Let's lower your hand. Jenny, please ask.
Hi, sorry, can you hear me now?
Yes.
Hi, good day. The question's for Delhi, please. Just with the wet ink signature story on our agreements of sales, surely the finality of a legal binding document sits with the transfer documents. So would our agreements not be binding still with e-signatures? And then the attorneys are getting the wet ink signatures from both parties on transfer documents.
No. They're not going to be valid. Remember, I read a case. So it doesn't matter what you intend to do at the end of the day. That electronic one is not valid. The one that is valid is the one that complies with the act. So if you submit one that is electronically signed, hoping that you have one that is obviously physically signed, then the one that is electronically signed is not valid. The valid one will be the one that is physically signed.
Okay, thank you, Daly.
Yeah, thanks.
Okay, thank you. Let's go to Faith.
Hi, can you hear me?
Yes.
Oh, yes. Hi, everybody. So I literally have learned something that actually here in South Africa, we don't really have a protection clause for the estate agents, whereby after the expiry of the mandate or else even during the period, a seller will intentionally cool off the sales agreement. I mean, the offer that an agent has presented. And at a later or else after the expiry of the mandate, the same seller actually approaches the purchaser and concludes an agreement. So this has actually made me aware of the fact that some sellers will intentionally avoid paying commission and manipulate agents to believe that their sales, their offers were not actually successful. And then later on, the deals are concluded behind the agent's back. And therefore, it is an input to say there must be a protection clause in our offer to purchase. But at the same time, I also want to ask this question to Delhi to say, Delhi, what is a cool off period after it's not a cool off period as such, the waiting period when the seller can actually conclude a transaction or a contract with the same purchaser that was introduced by an agent?
Thank you for that question. So it's just that I didn't, but there are a number of cases. If you can look at, unfortunately, there is no protection clause that we have in any legislation. But what has happened is that the courts have been able, where an estate agent has proven that this particular person was introduced to the property by them, to hold that seller to pay commission. There is no cooling off period. So long as you can prove that that seller, that buyer was introduced to the property by yourself, then the courts will be able to assist you and conclude that the sale was as a result of your involvement. You can read, there are so many cases in relation to this aspect. And I think one of the things that we have constantly said to practitioners is that when you get a buyer for a property, the first thing that you need to do is to get their details, even before you take them through to the property, is to get their details. And you can do that through an email. Say to them, please send me an email confirming that you would like to view this property. And then also some have what we call some signature books, where when you get to the property, you make the client sign that they viewed the property, and that's all you need to prove to the courts that this person was introduced to the property by yourself. And I think some even go to the extent of, when you make them sign your clause, will say, confirm that I'm the first person to have introduced you into the property. Then the client signs. There are many, many cases where agents have won. Obviously, it's a costly exercise because then you have to go to court. Thanks.
Thank you, Deli. I have a question here from Tatum. Hi, does evaluation need to be done on the property to confirm the sale price and included in the contract? Then he also has another question, Deli continues. It says, how does land claims work in regards to sales and contracts?
Lady, I didn't hear that. Can you repeat it for me? And I can't see the text. It's just...
No, I'm on the Q&A on the menu bar, so I'm reading them from there. The question says, does evaluation need to be done on the property to confirm the sale price and included in the contract? That was the first question. Did you get that? Deli?
Sorry, yes, I did. So when you do evaluation, I hope I'm answering it. You do an evaluation on the property. Is that what this person is saying? So you evaluate the property, but obviously we know that there are people that can do evaluations for property. It's not every property practitioner that can do evaluations, and we do know that, colleagues. Obviously, we can rely on valuations that have already been made on a property, but we can't do evaluation on property. It's done by proper valuers. So yes, you do the evaluation on the property. I don't know if I'm answering the question. I seem to be lost as well.
That's Tatum. If he needs clarity, can you please raise your hand and let's engage? Let's go to Caroline. I see your hand. You can unmute.
Hi, everybody. I've got a question for Kayleen. Just with regards to the CDD on an operational level, there is some debate in our office whether or not we need to batch or bundle each of the persons or applicants' individual FICA documents, so IDs, proof of residence, tax information, bank statements, whether we can actually file them as separate PDFs in a folder, or if they need to be bundled in one PDF. Now, in my mind, it shouldn't make a difference if we've got all of them together, but I just wanted her opinion on what would be the ideal practice.
Helen?
Yes, thank you for your question. I think that is more operational decision by the principal, perhaps. As long as all your files are audit ready, you must be able to reproduce your files within 48 hours, let's say, if you got an inspection. So whether it's all in one PDF document or separate, I think that's more the decision on the principal, perhaps, for filing purposes. As long as it's all in one file, I would suppose, for easy access, all your clients' files, all the files or separate files, one file is in a folder that is clearly stated, it's for that client. I think that is the most important aspect. The further operations from there or the further filing, that's really the decision or prerogative of the principal office manager, whoever is in charge of that aspect.
Thanks, Kaylee. That helps.
Pleasure.
Thank you. Let's go to Adrian. Please unmute. Adrian? Okay. Let me go back to the questions on the Q&A. And because there was another one from Tatum Daily, I'm not sure if you'll be able to respond to this one. He says, how does land claims work in regards to sales and contracts?
How does land claim work? Okay, no, let me think about it. I'm not sure if I understand the question. I'll respond to it, Naledi, now.
Okay, and I think also maybe come through Tatum, because give clarity, especially on the first one of evaluation that you were inquiring on. Let's go to Adrian. Please unmute. If you still want to ask your question, this is the last hand that we have. Okay, it's fine. He's not asking a question. Let me see on the chat. I think most of the questions that were on the chat, we did address them. And I also saw Daily, you put something on the chat where they can refer to on that tacit sale you had a discussion on. Okay, I see one from Fred. Please provide clarity when you start a sales process. No? I want to understand what you're saying. Please provide clarity. I think you wanted to say when you start a sales process. He has two questions. The first one is for the OTP, where the seller is overseas and the buyer is here in South Africa. The buyer signs the OTP. You can scan an email to the seller. Daily, if you were to take the contract, you scan it that side, they print it, they sign. I know you answered it, but maybe they joined later in the meeting and didn't hear the reply. Who prints and signs and email the OTP back? And the second one says, is it only the documents for the deeds office that must be original, which must be couriered? Are you aware on deed office documents?
Okay, so the both parties must ensure that the contract is physically signed. So if your buyer physically signs, then you can send it electronically to the seller to then also print and physically sign and send it back. So I think there must be just a differentiation that there are those electronic PDF signature documents, signatures that we have on our PDF. You can't use it to sign a contract, but you can send the contract once it's physically signed electronic to the other party, who must then also do the same, print it, sign it, and can also send it electronically. But here's the issue. Some conveyancing attorneys, for purposes of transfer, they need the original documents, or they will ask if you are abroad to go to a notarial so that it can be signed there. And then you can bring back the documents to the conveyancing attorneys, because remember, the deeds office liaise with the conveyancing attorneys and not the agent. So those documents definitely land at the conveyancing attorneys. Then the conveyancing attorneys will then proceed. I'm not sure whether the deeds office will then, but I think I stand corrected. They also need the originals. That's why the attorneys need the originals or the document that is signed in terms of the act, which is physically signed.
Thanks, Daily. There's another one from Noel. Good day. Are the OTPs to be signed for tribal or communal land?
No, colleagues, when it comes to tribunal lands, there is no OTP because you go to the chiefs. We all understand that. So there's no OTP for there's the I think they call it what certificate do they call it from the chiefs? There's certificate that is issued by the chiefs for you to occupy the land, because you can't own the land. You have permission to occupy. Yeah, I think it's permission to occupy the land.
Okay, Deli, while you're on the floor, I have Tabucho who says, is it mandatory to sign mandatory disclosure on mandate to let, even when the agent is going to do ingoing and outgoing inspection?
Yes, I think if you look at section 67, it says a property practitioner must not accept a mandate unless the seller or lessor of the property has provided him or her with a fully completed. So it's even when it comes to lease agreements, it must definitely be the mandatory disclosure agreement must be signed. I know when the Act was implemented, we did get a lot of questions from property practitioners saying the current mandatory disclosure form is only suitable for, for sales or for sale agreements or for people that are selling and not for people that are listing properties. And then I think what we did based on using the legislation, we then granted exemption under Section 64 where where estate agents and their companies would come with a list with the mandatory disclosure form where they needed to add onto what was in the current mandatory disclosure form that specifically speaks to lease agreements. So we've been able to do that. But for purposes of ensuring that we have mandatory disclosure form that speaks to leases, we are currently in the process of reviewing the regulations because the mandatory disclosure form is in the regulation such that we will then have a disclosure form that specifically speaks to leases. But the answer is yes, for lease agreements, you do need a mandatory disclosure form as per Section 67 of the Act.
Okay, thank you, Daly. Ian is asking the mandates, can they be signed digitally or electronically? But I know you touched on it. Maybe you can quickly touch on it again.
Yeah, so mandates are not part of an exemption. So remember I said that the Act provides exemptions to say, exceptions, sorry, to say this particular contract you can't sign electronically, but for all other contracts, the electronic signatures are valid. So mandates, yes.
Okay, Bongani says, should all co-owners of the property sign the mandate? Maybe Dale, you can touch on it again for record purposes for those who are going to listen.
Yes, if one of the sellers doesn't sign, then it means you don't have a mandate to sell the property because one of the owners has not signed. All the owners must sign as agreeing to the sale of the property. Remember, sometimes you can have a court order that orders the property to be sold by an estate agent. In that case, the reason why you would, which we have seen where you would have a court order is where the parties are fighting. And then where you have a court order, the signature of one person who is exercising their right to sell is enough. Where there is a court order, colleagues, where there is no court order, both parties that own the property must sign the mandate. Otherwise, that mandate will be invalid because you did not have consent of all the parties.
Okay, thank you, Daly. There's another one from Lisa. Are agents allowed to sign the disclosure form on behalf of the seller?
No, you can't sign on behalf of the seller. If you look at the disclosure form, there is a portion that requires the property practitioner to also sign. So if you sign on behalf of the seller and then you sign as a property practitioner, you're really going to get into trouble. The seller must sign from the sale, unless you have a power of attorney to sign. But I would really advise that let the seller sign. Don't sign on behalf of the seller. Because remember, if you sign on behalf of the seller, you are saying you are aware of these disclosures. You are saying whatever is stated here is correct. And I definitely would not want to put myself in a position of agreeing to defects in a property that I know nothing of. So the seller must sign the disclosure form. Then you, as a property practitioner, you sign where it says signature of property practitioner. Because there's three signatures: the signatures of the owner, signature of the purchaser, and signature of the property practitioner. So the seller must sign for themselves.
Thank you, Daly, for that. Ali says, is mandatory disclosure Excuse me there, it skipped up. Let me scroll up. Okay, I found it. Is mandatory disclosure applicable for commercial property? Mandeline?
Yes. Yes.
Okay, thank you. And Lizette, let me see what you're saying here. There is not an OTP as tribal land cannot be owned, only the right to occupy. I think you're answering Noel. Thank you, Lizelle, for your comments. And colleagues, I saw that you were trying to answer and assist, especially those, who have experience on this, to assist some of your colleagues. And maybe if they can need help, you can exchange numbers and try to assist each other so that they can get it right, especially with these guidelines coming up. Let me go back to Kelin. What are your maybe, comments and the highlights you want to touch on before we can close the webinar? Kelin?
Thank you, Naledi. So beneficial ownership, that is a legal requirement. Very important to evidence how you got to the beneficial owner, who the beneficial owner is, and who you identified and verified. So it can be shown because, as I mentioned in the presentation, the FEEC has requested at times sample files, which they actually will look at who was identified and verified. So very important to evidence, and remember the process of elimination when doing your beneficial ownership search. Also, just one more thing, Naledi, we apologize. It was a technical issue with the first link that was shared. We did reshare the link in the chat for the health check. So if you are interested in us to just see what you do have in place and provide some feedback, you're more than welcome to answer the questionnaire, which we will provide feedback on. Thank you very much to the PPRA, Naledi, and everyone who has attended for listening to my presentation, as well as Deli's awesome presentation. Thank you, Deli, as well. And yeah, have a lovely day further.
Thank you, Kelly. I see the link from Nomfundo. Please look at that on the chat. Deli, what is it that you want to emphasize, especially coming from your presentation, that colleagues can just take away, just emphasis on points?
Naledi, I see that someone is asking if mandatory disclosure form are compulsory for distressed properties. Yes, they are, especially if if you read the act, it says you must have a mandatory disclosure form for a property. But obviously, that is going to depend on who now is going to sign the disclosure form. And I know that we've had consultations with, for example, the banks as to who signs, because remember, when they sell the property, the person in the property is not willing to sell, so they wouldn't sign the property. They wouldn't sign the mandatory disclosure form. So I think those are some of the things that we need to also finalize with the bank, so that we see how we assist property practitioners, especially where they are selling distressed properties, so that it's now not the property practitioner who is now in trouble for having not attached a disclosure form. But so Naledi, just coming back to what you said, I think as the PPRA, we are quite aware of the issues that property practitioners faced. I know people were commenting about how sellers try to circumvent commission by then approaching the buyers directly when they have already done the work. So those are the issues that we do receive as complaints, but because we can't do anything about it, it requires the court to decide on these issues. Then as a PPRA, we are unable to assist. Other issues is where clearly, as the investigations department, we receive complaints against property practitioner where you can clearly see that, in fact, the property practitioner did all that they could do in the circumstances to help the buyer, to help the seller. But at the end of the day, they end up being reported. But as a department, we do investigate each case on its merit, and we ensure that we are fair to property practitioners where they have done what they need to do, and we're not going to simply proceed and charge the property practitioner. But also we are saying to property practitioners, there are a lot of things that you can do in order to protect yourself. Written communication is very important. It helps you to have evidence to back up your case. And yeah, let's continue to work and service our clients, but also ensuring that we protect ourselves so that we can get paid, because really our payment depends on, and it's a commission-based industry. If you lose one client because of a simple mistake, then your whole commission is gone. Thank you so much, Naledi. And let's remember to renew our FFCs for those who have not renewed. Let's continue to report illegal property practitioners so that as a department we can, or as an entity, we can deal with them. Thank you.
Thanks. Mavis raised the hands. Maybe let me hear from the speakers. Should I take the hand before I close from Mavis?
Yes, Naledi.
Come through, Mavis.
Kidding. Thank you. Yes, another colleague of mine will ask regarding the COC.
Oh, yes, good afternoon. I wanted to find out, is there a regulatory amount of the size of the gas cylinder in order to include it in the COC, or to be exception or to be excluded from conducting the gas COC?
The what? Did you hear that, Delhi?
She said a regulatory amount. What is
Yes,
a regulatory?
Gas size.
The
The
cylinder.
cylinder for the gas stove or any other gas appliances that you need to conduct a COC for.
But is that our jurisdiction, Delhi? Because that's electrical related, isn't it?
No, I wouldn't know. And I also think that I don't think there is, as long as it's a gas cylinder, then you must have that. It doesn't matter what size it is, because I'm assuming you are talking of the gas cylinders that obviously sit outside of the house. You know, once there's a gas cylinder installed, or gas installation, then you need that COC.
Thank you.
Carol?
I respect.
Carol? Carol? Okay, Carol, she's not winning. Colleagues, thank you so much for joining today's webinar. We're going to share the slides. We have your email addresses because you registered for the webinar, and we're going to share the presentation, like I've said in the beginning, on that we'll put it on our PPRA TV. If you're not following us on social media, colleagues, please follow us on TikTok, PPRA TV, on Facebook, Instagram, Twitter, and LinkedIn. This is where we post the workshops on where we are going, because on the 25th of March, Delhi, I know you are aware of this. There's a matter that was posted about an illegal property practitioner who's operating in Zeerust and defrauding people. So we need to go to Zeerust on the 25th of March to go and assist and speak to the consumers, and also ensure and do inspections as well, and ensure that practitioners have Fidelity Fund certificate. I see Lisa. Lisa, because we're about to close, I'll allow you. You'll be the last hand. Lisa, please unmute.
Good morning. Thank you so much for taking my question. My question was posed on the chats. It's a very quick one. I'll be quick. I wanted to find out, is it possible for you to recognize a disclosure form that's actually filled out digitally instead of the one that you actually print out, in terms of the rental side of things?
So when you say disclosure form, is it the one
The-
that is
the
prescribed by
checklist.
the Act?
No, not that one. The checklist. I'm saying when you're doing
Oh, it's
a
a
rental
checklist.
checklist. Yes. Can you have it digitally
Yes.
done? Okay.
Yes. Remember, it's done by, so you as the agent would do the checklist. Yeah, you can. As long as you've gone to the property and made sure that those things are in order as you tick.
Thank you so much.
Yeah.
Thank you for that last question. And I think the presentations were very
Sorry, Naledi.
interesting. Yes.
Just in respect to the Zurist issue, please make property practitioners know that we have submitted an affidavit with the Commercial Crimes Unit who are investigating the matter, and they are busy with a process to ensure that that property practitioner is arrested. We have also sent out communication to the industry and to the public, specifically mentioning the issue of this property practitioner and what he is doing. The consumers who have suffered loss, you know, when she was registered, because the consumers that have suffered loss after she was not in possession of an FFC will be compensated from the Fidelity Fund. But unfortunately, for those that suffered loss after she was not in possession of a Fidelity Fund, they will not be compensated. But we are working closely with the police, and we will come back to industry and confirm what has been done about that property practitioner. We've received communication from her attorney, which is interesting because she's able to respond to the PPRA through her attorneys, but she refuses to respond to the consumers who have suffered loss or who she has defrauded. So we are working closely with the police and ensuring that we deal with that matter. Thank you.
Thank you, Daly, for the steps that you're taking in your department to deal with illegal trading of property practitioners, because there's a lot of them, and we know the whole of South Africa. You know, this is why we do education and awareness, and we go physically there. Even our inspections department, they ensure that they go check if your FFC is on the wall, if you are placing it, if it's visible, and you have renewed and complied with all the compliance in respect to audit for those who have auditors' reports. Colleagues, I want to say that I will try to bring you other topics that might be relevant for your businesses and what you do. You know, this is just for empowerment and just to bring awareness, and you can ask the speakers questions so that you can get clarity. You know, I picked up that there's a need that we need to invite FIC. I will communicate with them so that we can set up a webinar on that. And thank you, Daly, you know, for giving clarity, especially on the cooling off period and on the breaches of contracts. And Kelly, thank you as well for just touching on the importance of beneficial ownership. You know, it was very interesting. So colleagues, it's 12 o'clock. It's time for us to close now. It's time for us to adjourn the webinar. I will share with you the slides. Enjoy your lunch and may you thrive in all your businesses. Thank you so much. Goodbye, colleagues. Thank you, speakers.
Thank you.
Thank you,
Thank
Naledi.
you.
Thank you, ladies and gentlemen. Thank you.
Thank you.